1, much like the schedule we've been doing on Friday. We'll also do that schedule on Friday. Does that work with you all? 9 to 1 on Thursday? That'll give us a little bit more time to get those matters in. Should we run long?
Yes, Your Honor, that works.
Yes, Your Honor. Thank you all.
And for the state defendants, is that okay?
Yes, Your Honor.
Okay, thank you, Mr. Cox. We also would plan on stopping today at 4:30 for the introduction of exhibits. I know yesterday we kind of interrupted right at 5 o'clock when we were in the middle of that. Mr. Thompson, do you have other exhibits today? And would that be a good choice to stop at 4 today, you think?
Or did you say 4:30, Your Honor?
Yeah, I meant 4:30. If I said
Yes, Your Honor, that we would greatly appreciate that. That would work well. Thank you.
all right. And so now back to the issue at hand with Ms. Riggs' objection. We're going to sustain that objection. Okay, so the witness will be allowed to testify as a fact witness, but not as an expert. Any other things before we allow Ms. Moss to resume that direct examination?
Your Honor, if I may, and I understand your ruling, but for the record, I'd appreciate an opportunity to state our case. So when this goes up on appeal, that'll be there, and then to likewise suggest that. As I believe was done earlier, that I be permitted to ask my questions, and to the extent that they are as a proffer, so that we will have in the record what Ms. Strzok's responses would be, and that if Ms. Riggs has specific objections that any of my questions in her view stray into inappropriate expert testimony, that we have that on the record, so that the information we want to get into the record will be there for appeal.
That's fine, I'm sure. I'll certainly allow you to make that proffer.
Okay.
When would you like to do that?
Well, I'd like to do it now, and I guess my response would be, I believe that Ms. Strzok, through the questions that I elicited from her, makes clear that her expertise is based on her 20 years of experience administering elections here in North Carolina. The Rule 702 of the Rules of Evidence do not require that an expert's expertise be based on the fact that they have published in peer review articles, or that they have any specific education or training. She certainly has training and education related to investigations, but beyond that, her experience, as she has said, is really based on her years of experience. Indeed, there is no one else in the state of North Carolina who has more experience than Ms. Strzok. She is the only person who has ever served as the chief elections official when a voter ID law was implemented in this state. And that is the expertise that she is bringing to bear. And in addition to, overseeing during her time as executive director, approximately 16, if not more, elections in which she has been required to implement election laws. And so that would be our basis for her being an expert, and why we would object or oppose Ms. Riggs' motion. I understand your ruling, but I appreciate the opportunity to put that on the record.
Absolutely. One question I have is, obviously, even though she's a fact witness, their fact witnesses are allowed to give lay opinion testimony. And so this witness is no exception to that rule. I'm wondering, though, about your proffer of the questions that you'd like to ask her as an expert, and thereby elicit opinion testimony, versus your questions that you'd like to ask her as a lay witness, a fact witness, that elicit an opinion type response. So that can get a little tricky, because I want Ms. Riggs to be able to object to those questions, but I want to allow you to make your proffer. And so we may run into a scenario, maybe I'm overthinking this, where you're making a proffer of the proposed expert opinion she would render, and Ms. Riggs may not object because it's a lay opinion. You follow what I'm saying? And maybe I'm not articulating it exactly right.
I believe I understand, Your Honor, and I think that is why I believe the default should be that my questions are appropriate and in the record and not objected to unless Ms. Riggs objects to one of them specifically for precisely that reason. There is no doubt that Ms. Strzok has a wealth of experience and firsthand knowledge that she can testify to. I, of course, can't know or anticipate what Ms. Riggs will object to, but I can tell you, I can forecast, for example, that we certainly are going to be asking her, based on her experience and her deep her deep knowledge about the implementation of the prior photo ID law and her study and knowledge of the current photo ID law, both for purposes of this case, but because she was the chief elections official when the law was passed and during the first several months that it was in effect. We're going to be asking her, I will be asking her opinion on the differences between those laws. And in her opinion, and I'm based on her years of experience, does she perceive that there should be a difference in how, for example, the reasonable impediment process will proceed under Senate Bill 824 that would differ from how it proceeded under House Bill 589? I believe that she can offer that testimony both, we have proffered her as an expert, but I also believe that that would be appropriate as a lay witness based on her personal experience and knowledge.
Ms. Riggs, what do you say about that? You're on mute.
Your Honor, thank you. Just to respond to some of Ms. Moss's narrative for the record, first, of course, this court has ruled, and appropriately under Rule 702, even if an expert were qualified based on experience, Ms. Strzok's opinions aren't reliable. She didn't record what voters she's talked to. Her report is absent from the kinds of testable facts that would render her testimony reliable. But regardless, Rule 701 says that if an expert is not testifying if a witness is not testifying as an expert, her testimony in the form of opinions or inferences is limited to those opinions or inferences which are A, rationally based on the perception of the witness, and B, helpful to a clear understanding of her testimony or the determination of a fact and issue. Respectfully, so we avoid the issue that came up with Mr. Huff, if the question falls outside of that, Ms. Moss needs to clarify the record that this is a proffer question and make that clear so that I can make my objection. Otherwise, we're going to be objecting to every question, I suspect.
Well, I tell you what, let's just go forward with the direct examination at this point. And Ms. Moss, if you come up to a question that you say, I know the court has ruled on this, and we'd like to ask this question for purposes of making a proffer, then I will know it's a proffer question. If you'd like to ask a question that you say, well, we think this falls under Rule 701, then state that as well, and we'll go forward. But I mean, I don't know how to just give a prophylactic ruling that covers everything. We'll just have to go it as best we can, and we'll get through it as soon as we can. So, Ms. Moss, ask your next question.
And just bear with me a moment, Your Honor, given that her reports are not, well, let me first say in terms of a proffer, just so I'm clear, of course, it was our intention to offer her expert reports in evidence as her direct testimony. We would ask that they, again, that understanding the ruling, that they come in not for, for the purposes that they're in the record as a reflection of what her direct testimony would have been but for the court's ruling, so that
we definitely would receive those as part of the legislative defendant's proffer of evidence in the case.
Okay. And Your Honor, just to be clear, we do object to the entrance of JX 50 and 51 to the extent they reflect improper expert testimony, contain hearsay that Ms. Strzok is not entitled to rely upon, and contain much untestable, unreliable information, just for the record.
All right. we understand that objection and it's been sustained, but we're still going to allow her to put it in so that the appellate court knows what we sustained. You may ask your next question, Ms. Moss.
Okay. Ms. Strack, did you prepare 2 reports in this case?
Yes, I did.
Okay. And the initial report, if we could bring that up on the screen, it's JX50. Do you recognize this report as the merits report that you submitted in this case?
I do.
During your time as executive director of the State Board of Elections, did you have any responsibility for implementing the prior photo ID law, frequently referred to as VIVA or House Bill 589?
Sorry, Ms. Moss, you broke up after prior photo ID law. There's some kind of interference on the microphones, but you broke up after photo ID law.
And I apologize, I'm hearing the interference as well. I was asking, let me just re-ask the question. Did you have any experience during your time as executive director of the state board in implementing what has been known as the prior photo ID law, what has been known as VIVA or House Bill 589?
Yes, I was tasked with implementing House Bill 589.
And can you please describe for the court what your responsibilities were with respect to implementing that prior law?
Well, with House Bill 589 passing in 2013, it had several components that would be enacted at different times. Certainly, the photo ID provision was to be to go into effect for the first time for the 2016 elections. And so we had a rollout period, and we had certain things that we had to do in order to prepare for that first election in 2016. There were other components of that law too that we were implementing at the same time. That law, one of the things that it did was that it shortened the one-stop early voting period, but it required counties to match hours. So we wanted to educate people about that. It took away the ability for voters to vote out of precinct. And that was something we wanted to make sure voters would not be disenfranchised because they were appearing at a precinct of which they were not registered. It eliminated same-day registration. And so that was another thing that we had to try to make sure that we were really vigilant on ensuring that people understood the voter registration deadlines because they had voted in the past since 2008, I believe 2008, using same-day registration. And there were some other components to House Bill 589 that we were implementing as well. But all of those things were taking place while we were trying to carry out the rollout of that. And part of the rollout was to ensure that we were doing everything we could at the state board of assisting people with getting an acceptable ID that they could use in the 2016 election. So that's when our outreach team was tasked with dealing with those other components of the House Bill 589 that would be rolled out in 2014. But also at the same time, they were tasked with doing what they could to make sure we could identify as many people that may not have an acceptable ID and equip them with that ID so that they could show it during the 2016 election.
Okay. And can you please describe for the court, broadly speaking, what the outreach strategy was of the State Board of Elections in reaching out to voters regarding the new voter photo ID requirements and the need to obtain ID?
Certainly. It was a multifaceted approach because we wanted to make sure, number one, some things were going to be time sensitive, that we didn't want some of our campaign, we needed to come later in the process. But the thing that we could immediately do was do targeted mailings to those individuals, voters that were on the rolls that we believed did not have acceptable ID, and then have our outreach team to work with those voters individually if they require or ask for our assistance. So that's one of the first things that we did is we tried to identify best way the State Board of Elections could. We had DMV data, but that's the sort of the data that we used to try to do a matching analysis to say, these are the voters we want to mail to. We want to mail to them and tell them that they might not have acceptable ID, but we also want them to respond back to us and let us know if they do, and if they don't, what assistance we could help provide them. Another thing that we did is during the 2014 and 15 elections, we obtained, and this was pursuant to the law, we asked voters if they did have acceptable ID for 2016, and if they did, indicated to us that they didn't. That was another way our outreach team would reach out to those voters and try to determine if they did in fact not have an ID, and if they didn't, how could we assist them in obtaining them.
Okay. Let's talk a little bit about the assistance that you provided and the targeted mailings that you did. If we could Ms. Hardiman, could we pull up JX 878 on the screen? Ms. Strock, do you recognize this document, which is entitled Prior Education Efforts on Voter Identification Requirements 2014 through 2016?
I do.
And why was this document created?
As I recall, that was a presentation we were trying to show the efforts that we had made in advance of the 2016 election, of the education efforts that we had made to ensure that voters had the opportunity to get acceptable ID, and the efforts that we made to assist them in doing that.
Was this presentation given to the General Assembly in November of 2018?
Yes, it was.
If we could turn to page 17 of this slide deck. Now, I believe that you had just mentioned on your direct testimony that in addition to targeted mailings, you received some acknowledgments or information back from voters. Is this slide, is that referring to the same thing that you were testifying about?
Yes, it is.
Okay, so explain in a little more detail, if you will, what you did to try to determine if voters had acceptable identification under the prior voter ID law.
Right. So at the 2014 election, we had every voter that presented there was asked whether or not they had acceptable ID, and if they didn't, to sign an acknowledgement a form, and those forms were then passed from the counties to the State Board of Elections. And the State Board of Elections in 2014, there were the 10,743 voters. And we then provided a mailing to those voters requesting them to respond back to us about whether or not they in fact did have an ID at that time and whether or not they needed our assistance.
And did you do something similar in 2015?
Yes, we followed the very same process with all the municipal elections. Every voter that presented at a municipal election, which would have been in September, October, and November of 2015, every voter was asked whether or not they had acceptable ID, and if they didn't, they were asked to sign an acknowledgement form so that we could use that then for outreach efforts. And we then also sent another mailing to those voters with the same asking them whether or not they had an ID, and if not, if they needed assistance from our staff from obtaining one.
Okay, if we could go to the next slide, please. Now, the first bullet on this slide, it refers to the voter outreach team sending a mailing to each voter. Is that what you were just describing?
Yes.
Okay, and based on the slide and to your knowledge of the voters that were sent a mailing, how many responded?
Of the one, there was, in 2014, there were 2,353 responded to our mailing.
And how many indicated in response to that mailing that they did in fact possess acceptable identification?
It was 95%. I don't have the exact number by memory right now, but it was 95% of those 2,353 voters stated back to our outreach team that they did in fact have acceptable ID.
And then some number of voters requested assistance. Is that correct?
That's correct. And I think it was 51 for the 2014 mailing.
Okay. And then if we could go to the next slide. Did the State Board of Elections do something similar with respect to sending mailings to individuals that showed up on a no match list that was generated by the State Board of Elections?
Yes, we did conduct database matching where we matched voter registration data with the DMV data. And if a voter did not match with a DMV record, then that went on our no match list, and every person on that no match list was provided a mailing, was sent a mailing, and the mailing advised them that it appeared they may not have acceptable ID. It asked we provided a self-addressed envelope back for them to respond back to us, or card, excuse me, back to us of whether or not they in fact had an acceptable ID, and if not, whether they needed our assistance in obtaining acceptable ID.
If we could look at the next slide. And does this slide provide information on how many voters returned a response to that mailing?
Right. There were 20,580 returned a response, which was 91%. Excuse me, and 91% stated that they had an ID.
So 91% of the 20,580 who returned a response indicated they in fact had an ID.
Yes, that's correct.
And then did some number of voters request assistance?
Yes, from that mailing, there were 633 voters that requested assistance.
Okay. And if we could look at the next slide. And did you do any further mailings based on a no match list that was created by the plaintiff's expert in the NAACP versus McCrory case?
Yes, we did. Dr. Charles Stewart did a matching. He had a no match list as well that was presented in the litigation with House Bill 589. And so what we wanted to do is he had access to more ID data than the state board had access to. And so we took his list, and we took all the people off there we had contacted. But the ones that we had not contacted, we sent a mailing, the same type of mailing that we sent with the matching criteria that we had done. And we asked for a response back in the same way of whether or not they had an ID or whether or not they needed assistance.
And how many voters responded back to that mailing?
8,440 returned a marked response.
And how many of those indicated that they in fact had acceptable identification?
76%.
And then did some number of voters request assistance?
Yes, 782.
Did the State Board of Elections form any conclusions following the issuance of these various mailings to voters and the return of responses indicating somewhere between 76% to 91% of respondents claiming that they already had acceptable identification? Did the State Board of Elections form any conclusions regarding the accuracy of the no match list based on that?
Well, obviously, in putting the no match list together was our best effort at determining voters that didn't match the DMV database. We were certainly glad to get responses that people in fact did have acceptable ID, but this was not was not as reliable of an indicator of people that we could reach out to as we had hoped, because we had so many that were not returned, or from the ones that we had that were returned, there was such a high percentage of them that had acceptable ID. So we were hoping for a better way of identifying voters that may not have acceptable ID.
Okay. So now I'd like to turn your attention to the assistance that was provided to voters who requested it. Can you please describe for the court what some of the efforts were that were made by the State Board of Elections outreach team to provide assistance?
Certainly. The outreach team was sort of tasked with, we wanted to go and do whatever we could to try to assist the voter in getting an ID. Sometimes the voter lacked transportation and didn't have the ability to get the documents they needed to get to the DMV, or couldn't get to the DMV. And so what we would do is we would try to do what we could to arrange transportation. We had agreements with public transit organizations that we could provide free vouchers for them to do that. We had occasions where we would try to arrange for people to get the documents or the ID that they needed. And we had on occasions that we actually drove to the voter's house and transported them to get the ID. So the outreach team was tasked and did make every effort they could with trying to determine what it was the voter needed and trying to find a way to make that happen.
Okay. If we could bring JX 878 back up on the screen, please, and go to slide 23. On this particular slide, this presentation indicates that the voter outreach team worked with more than 2,700 cases. Is that consistent with your recollection?
It is consistent with my recollection. We had weekly meetings and discussed these numbers, so that's very much my recollection.
And it goes on to say that they established agreements with 97 transit systems across the state to provide transportation to and from DMV offices at no cost to the voter. Is that also consistent with your recollection?
Yes, it is.
Based on your years of experience working with the State Board of Elections and specifically with the outreach team in providing this assistance, is there any reason, to your knowledge, that the State Board of Elections could not establish similar agreements today if voters needed assistance in getting transportation to a county board of elections office?
The objection calls for speculation.
Objections overruled, you may answer.
It's my belief, I'm basing this on the fact that there is still an outreach team in place at the State Board of Elections. Some of those members were part of the outreach team during the implementation of 589. The outreach team established those relationships in order to make those agreements. And so I feel certain that they already have those relationships. They could certainly do that again.
And in terms of the types of IDs that are available under Senate Bill 824 as compared to the prior HB 589 law, are you familiar with the types of free IDs that are currently available? Well, would be available but for the injunction?
I am familiar with the free ID provided by the County Board of Elections. Yes.
And had that type of ID been available when you were implementing House Bill 589, how would that have impacted your ability to provide assistance to voters?
Objection calls for speculation.
The objection is sustained.
Based on your experience in implementing 589 and providing assistance and overseeing the outreach team that provided assistance to voters in obtaining ID from the DMV offices, did the fact that documentation was required present any particular issues?
And that was, I would say, a great number of I will call them cases, as referred to in that slide. The cases that were opened by the outreach team for voters that did not have acceptable ID. That was certainly some of the things that they needed in order to go to the DMV, because you did have to have documentation in order to get a free ID at the DMV.
And in your experience, would the elimination of a documentation requirement help the State Board of Elections assist voters in obtaining ID?
Objection calls for speculation.
Sustained.
Your Honors, I would ask as a proffer that she be allowed to answer that question so that the record is clear for the Court of Appeals.
Sure, go ahead and answer the question.
Certainly, this, as I read House Bill Senate Bill 824, the free ID that the county boards provide, that each county board of elections will provide a voter, doesn't require any documentation. And certainly in outreach efforts, we were trying then in House Bill 589, our outreach was to try to find the easiest way to get a particular voter the acceptable ID they needed. That certainly would be easier if a particular voter didn't have documentation. That would be something where you could certainly get them to the County Board of Elections where they would not have to provide actual documentation.
Ms. Strzok, were the free IDs that are provided for under Senate Bill 824, was the equipment to be able to provide those free IDs made available while you were still executive director?
Yes. That equipment, we ordered that, and that equipment came in while I was still at the State Board of Elections, yes.
And did you have the opportunity to see that equipment set up and function?
Yes, I did.
Your Honor, can I interrupt just to make sure I'm clear? And I think it is, the proffer is over, correct?
Yes, it was to that question, to the one question.
Sorry.
That's okay. You may proceed. I'm taking it. If she says I want her to answer a question for purposes of making a proffer, then once she finishes answering that question, the proffer's over.
Okay,
So,
thank you for
so
that
another
clarification.
question is asked that you think is objectionable, then certainly object again.
Thank you for that clarification.
Sure.
So I believe I was asking you if you were familiar with the equipment used to issue the free voter IDs and whether that equipment had been ordered while you were still the executive director.
Yes.
Okay. And did you have the opportunity to see an ID card being made using that equipment?
Yes.
And what can you tell us about that? How long did it take, and was it a difficult process?
My recollection of we had a meeting where it was rolled out to our outreach staff, and I was part of that meeting. And it was a very quick process. The demonstration that we had, and we didn't have any issues. It's a fairly small product. So yes, we didn't have any issues before I left, and that was sort of in the how we were going to roll it out to the counties. It's kind of where we were in the point to do that right before I left.
Were there discussions and considerations by the State Board of Elections before you left about providing a mobile option for providing free ID cards?
There were discussions with the outreach team because, as I said, the outreach team had just worked on House Bill 589, and they certainly were glad, I believe, to have the opportunity to have the ability to print voter registration, photo ID cards. So yes, they were small enough that there were discussions about that they certainly could be used at mobile, on a mobile service.
And then turning back to the outreach campaign that you undertook when you were the state elections director, implementing the Viva litigation, apart from the mailings that we've already discussed, did you oversee the production and distribution of any printed educational materials?
Yes, we did. Part of our educational efforts were to print flyers, things that could be distributed at events where our outreach team would speak. It would also be events where we would work with community groups, and we could provide them the actual materials that they could use to disseminate to other members of their groups. So we wanted to make sure we had printed materials that could be used in our outreach efforts, not only just in where the groups where we went and provided, but also to provide other community groups or any group that wanted information. We wanted the ability to provide them with the materials that they could then distribute to their constituencies or communities or their groups.
Do you consider the creation of these outreach materials to have been standardized?
Objection calls for improper lay testimony, lay opinion.
Your Honor, if I may be heard.
Sure, you can be heard. Well, let me say this, overruled. You may answer the question.
They were uniform. The information was done so that we would have uniformity in the materials that were going out. And these were the materials that came and went out to all the groups, only came from the state board. They were all the materials that were disseminated to the county boards or any other group was uniform in nature so that we had a consistent message that was going out. So if a group was handing out literature that we understood, if it was coming from the state board, we understood that the message and that the information was uniform and consistent.
Did you work with anyone apart from the county boards of election in the dissemination of this outreach materials and information about the prior photo ID law?
Yes, we worked. I called them, and our outreach team called them partnerships. What we did, the outreach team wanted to do was we were trying to identify groups or communities that would be most likely not to have photo ID. And I talk about that with meaning like the elderly or groups where there's people with disabilities or low socioeconomic conditions. And so we tried to partner with groups that were reaching those communities, even if we couldn't, that they were reaching those communities. And we considered them to be our community partners, and we had a great number of community partners that we were able to do that. We also considered the county boards to be our community partners, and so they didn't come up with their own campaigns or literature, but they partnered with us to help us in the dissemination.
Were any of the materials that you developed generic enough that they could be used apart from House Bill 589?
Yes.
Objection calls for speculation.
Overruled. You may answer the question.
Yes, when we were, especially with our TV and radio ads, you always have the expectation when a law is passed that it will continue to be the law unless there's some sort of sunset on that law. There was not on this requirement. And so we wanted to make sure that we shot TV ads and radio ads that were what we call evergreen, so that they could be used in future elections. We had some that were specific, but we had some that we wanted to make sure that we could use because they're very expensive to produce. And so, yes, there are, I will call them evergreen TV ads and radio ads that can be used in subsequent elections.
All right, let me go ahead and interject right here. We'll start back with this testimony tomorrow morning at 9:30. Ma'am, are you able to be back then?
Yes, Your Honor.
Okay, then we'll start back at 9:30 tomorrow morning. Ms. Drack, you're free to leave the courtroom, and we'll see you back here then. I want to turn it over to the legislative defendants for the introduction of evidence at this time. Mr. Thompson.
Yes, thank you, Your Honor. Ms. Moss will be moving some evidence in. Thank you very much.
Okay, Ms. Moss.
Yes, and please just give me 1 minute to shift gears here.
Sure.
Okay. So we will, Your Honor, we will certainly have some additional exhibits at the end of Ms. Strzok's testimony, but I do have some additional ones I would like to move in now. And these were shared with the plaintiffs this morning. They may have responded while I have been doing my direct, and I'm not aware if they did, but so I don't know if they have objections or not, but
I can speak to that briefly, Your Honor.
Okay.
Plaintiffs did respond to Ms. Moss's email from this morning, approximately 15 minutes ago during her direct examination of Ms. Strack. And plaintiffs have identified which exhibits they plan to object to in that email and which ones they do not plan to object to.
Okay, so Ms. Moss, can you pull that up real quick? And
I can certainly try to. Okay. Think this really quick. Okay. And I now have that in front of me. So I do have that in front of me. I can't promise that I've read everything in it, but I do see the list of the exhibits that the plaintiffs are apparently going to object to. So the first set of exhibits that we would like to move in, and if I'm reading this correctly, and again, since I just got this email, I'm sure plaintiff's counsel will correct me if I misstate anything for my quick read, but I understand that these are coming in without objection, would be JX59, which is Dr. Thornton's report at the PI phase of the case, and JX800, which is Dr. Thornton's rebuttal report.
No objection from the plaintiffs.
JX59 and JX800 are received into evidence.
In addition, we're moving in for demonstrative purposes only LDX 183 and LDX 260.
No objection to the admission of these exhibits for demonstrative purposes only.
Can you give a brief explanation of what LDX 183 and LDX 260 are? I know you said they were demonstrative exhibits, but
yes, these were slides. These were demonstrative exhibits showing slides of possession rates that Dr. Quinn had referred to in his direct, and then Dr. Thornton referred to them. The second slide, LDX 260, was a slide that Janet Thornton used to show how she believes the appropriate presentation of the possession rates should have been depicted in terms of so those are its slides.
LDX 183 and LDX 260 are received into evidence for demonstrative purposes.
The next set these are articles and other data cited by the experts in their reports and asked about on cross-examination. And we're seeking their admission under the same ruling from the court that they come in as materials that the experts have relied upon.
Okay.
And that would be LX 17, which is an article by Grimmer and Yoder. LX 165, which is a book excerpt by Kauser. LX 177, which is an article on voter registration, the process and quality of lists. LX 178, which is American National Election Study FAQ. LX 182, which is an article by Cobb, Greiner, and Quinn. And LX 217, which is a 2014 YouGov poll.
Plaintiffs do not object to any of the exhibits that counsel just listed, provided that they are admitted to show that expert witnesses relied on them.
Okay. LX 17, 165, 177, 178, 182, and 217 are received for those purposes.
We have two other exhibits which were used by experts. One is LX 176, which is a Department of Justice printout information from the Department of Justice website about Section 5 of the Voting Rights Act. And then LX 210, which was President Carter's statement on efforts to restrict voting access.
Your Honors, plaintiffs do not object to the admission of the Department of Justice statement, which I believe is LX 176, but plaintiffs do object to the admission of former President Carter's statement as hearsay if it's being offered for the truth.
What,
I'm sorry.
in what context was President LX 210 used? Was it something you say an expert relied upon, or what was?
No, Your Honor, it was used on cross-examination with Professor Lolotis in discussing with him President Carter's statements on whether it was appropriate, whether the Carter-Baker report was being used appropriately. And so Professor Lolotis talked about the Carter-Baker report, and then this was further information as to that report.
Your Honor, plaintiffs contend that that is still seeking admission of the President Carter's statement as hearsay evidence for the truth of the matter, and therefore it should not be admitted.
All right, give me just 1 second here. Let me just say before I do, LX 176 is received for the same purposes as being something that experts relied upon, but the objection to LX 210 is sustained.
Thank you, Your Honor. And plaintiffs just have one more point to raise about LX 210. Plaintiffs believe that there have been two exhibits submitted by opposing counsel with the stamp LX 210 both the statement by former President Carter and the list of one-stop early voting locations in the 2020 election in North Carolina?
Ms. Moss, do you know about that?
I don't, but certainly we can look into it to see. I don't. Let me see if we've offered 210 before.
If it helps, Ms. Moss, it's on the list for former Director Strack.
And Your Honor, I think that is correct, and I think I probably misspoke. It would be LX, I believe it's 211 would be the Carter statement, not 210. I think I had the number wrong.
Okay, well, the objection to LX 211 then is sustained. And we'll not address 210 at this point.
Thank you. And thank you for bringing that to my attention.
Well, and also I'll just say, though I am sustaining, that we are sustaining the objection to LX 211, you can certainly make that part of the record for your proffer. So any exhibit that you are offering as an exhibit and we sustain, I still believe that you can transmit that exhibit to the clerk for preservation of the record.
Okay, and then the final set of exhibits that we wanted to move in today or get a ruling on, and we'll move them in later if necessary. These are documents that we believe that the court can take judicial notice of under Rule of Evidence 201. They're a set of documents that were used with Noah Reed on cross-examination. They consist of LX 225, which is a link transit pamphlet, LX 227, which is a regional system map, LX 228, the ACTA homepage, and LX 229, the ACTA services tab page. Each of these were exhibits that Mr. Reed authenticated during his cross-examination. He indicated that he was familiar with this information. He was examined about them. And again, we believe that they are of the sort of information that the court can readily take notice of under Rule 201, in that they are readily discernible facts that are not subject to legitimate dispute in terms of their information about the transit systems in Alamance County.
Your Honor, plaintiffs object to the admission of these exhibits as hearsay offered for the truth of the matter, and plaintiffs also contend that Mr. Reed did not expressly authenticate these exhibits during his cross-examination.
And my response on the hearsay, Your Honor, would be that they fall under either the public records exception or under the general catch-all exception, in that these are documents that are available from a website that's readily identifiable with these entities, and that they certainly purport to provide factual information that would be important and necessary for the court's consideration, and not subject to legitimate question as to its accuracy.
The objections overruled. LX 225, 227, 228, and 229 are received.
And Your Honor, that is the list for today. As I indicated, we will have some additional exhibits that we would like to offer after Ms. Strzok's presentation. And in addition to that, I did have one question. I believe we would like to move in evidence portions of the deposition testimony of Plaintiff Fred Culp, and we weren't sure as to how the court would like to receive those deposition designations that we would be offering as admissions of a party opponent.
Do you know what portions of that deposition you want to admit?
We do, Your Honor.
Do the plaintiffs know?
We have exchanged potential deposition designations with the other parties. We have certainly called down what we were going to introduce. So I can certainly provide them with the called down list to see if they have any additional, concerns, objections, or belief that additional materials needed under the rule of completeness. Or we can move in all of the deposition designations that were exchanged initially. I am open. I don't have a.
Okay. I just wondered if they knew exactly what portions you were wanting to admit. Mr. Simons, do you know which particular portion she's seeking to admit of the deposition of Fred Culp?
We do not, Your Honor, and plaintiffs would request the opportunity to review the designations and offer counters.
Okay, Ms. Moss, can you forward that to Mr. Simons, and I'll give you that opportunity, and then we'll go from there the next time we go into the introduction of exhibits, okay?
Certainly.
What is that all you had, Ms. Moss?
Yes, Your Honor.
Okay, I know that when we left yesterday, hold on just a second. Okay, so you asked to admit PX83, which was a podcast, and we had a conversation about the fact that was a plaintiff's exhibit number, and I mentioned to you that perhaps you could renumber that as a defendant's exhibit rather than admit a plaintiff's exhibit. And I'm assuming that, when I hear this PX, I'm assuming that's plaintiff's exhibit. And I hear LX, I'm assuming that's legislative defendant's exhibit. Am I right in that, or is that?
No, you are correct, Your Honor, and we renumbered it, and I can tell you for the record, we redesignated it as LX 261, and we left the title of it as PX 83 podcast. So it would be clear that LX 261 is the podcast that plaintiffs originally used, but that we, the legislative defendants, are moving in evidence.
LX 261 is received, which for the record is also PX 83. I don't know that I officially did that yesterday. All right, are there anything else for today then?
Your Honor, not for the legislative defendants.
How about for the plaintiffs?
Not for the plaintiffs, Your Honor. Thank you, Your Honors, for your time today.
Sure. How about for the state defendants?
No, Your Honors. Thank you.
Okay, then looks like tomorrow then we'll start back with Ms. Strock's testimony at 9:30. And then was that your last witness, Mr. Thompson?
Yes, Your Honor, it is.
Ms. Moss, do you know approximately how much longer you have on direct, or Ms. Riggs you would have on cross? Is she going to take all day?
I obviously can't speak for the plaintiffs. I suspect that she may take the better part of tomorrow, yes.
Okay, all right. And so Ms. Riggs, were you planning on Thursday morning, you're planning on your rebuttals being here then?
We were planning to start our rebuttal case tomorrow. It may take longer with Ms. Strack with proffers, but we will have a rebuttal witness, our first rebuttal witness, ready to go tomorrow.
Okay, fair enough. Well, we won't plan it out too far, but just wanted to sort of see where we were, and I think I've got that answer now. In any event, hope that you all have a good evening, and we'll be in recess until tomorrow morning at 9:30.
Thank you, Your Honors.
Thank you, Your Honors.